Hi guys, it's Kathy. I hope you're doing well. Oh, Kelly, no, nobody bullied me into doing this. You don't know how terrible it is to rest. I've had a rest for the last since Sunday, and I can't stand resting anymore. It's torture just sitting there resting. So yeah, but I overslept because it was music bingo at work, and I was sick, but it was music bingo. So I was dancing and singing loud, and I used up every single ounce of energy I had, and it was so fun. It was so fun to be standing up and moving and walking. Now I don't know what Lori went through. I'm not saying I know what Lori went through, but every time Lori said, "I don't want to rest anymore," you don't understand. I can't rest anymore. I understand a little bit. I didn't want to rest anymore. I want to go do something. It's hard for me to just rest. Snoopy's here. How are you? I missed you. I'm glad Snoopy's here. I can't really read text at all. Guys, you're about to see the most professional stream that you've ever seen on this channel. I mean, it is so professional. And then at the end, we're going to go over the list that you guys made for Fozzie. So you still have time. I guess I should put a link up real quick if you want to add. So remember, oh man, we have this list for Fozzie. I did ask you guys to keep it appropriate because I'm streaming it and you didn't. But that's okay. I'm still going to I'll get the link once I start the video. So I'm gonna get the link. I'm gonna put it up. If you haven't already, you still have time to add something to this list from Amazon that you think Fozzie should want, that Fozzie should have. This is what you think Fozzie should have. It doesn't matter what his opinion is in this. So there's some good stuff on there. We're gonna have a ball looking at this stuff, guys. All right. Now, Rebecca sent me this. Throw the Goat sent me this. Sorry. And it's from our Nevada judges, and they are so freaking good. I remember watching them back while Talk with Mike would show them. Um, oh, I don't know if Fozzie just threw the link up or not, so I'm just gonna click it. Yeah. So yeah, Law Talk with Mike showed me our Nevada judges a while ago. Rebecca sent me this link. This is just one part of this. There's more parts. So please, the link to our Nevada judges is in the channel description. Go there and watch the rest. They are absolutely professional. The most professional of professional. You'll see why I say that right now.
All right, I'll withdraw the objection. I'd like you to look at Exhibit G. Sorry, I'm going to strike that. I don't need to go with all these. Ron, would you possibly take like a 10-minute break?
Yeah, that's fine.
Okay,
You wanna
and
take a
then
break?
just finish up with him.
We just started.
We're back on the record time.
We are back on the record in the matter. Mr. Keller, you have some additional questions for the
I
witness?
just, two more. So, Mr., you're asking that the court award you not just the house, but also your remaining funds from the sale of L 115, is that right?
Yes, I thought that was already taken care of with the prenup.
Okay. No further questions, Your Honor.
All right, cross-examination?
Thank you, Your Honor. Now, you talked about Christmas this year versus last year. Last year you hadn't rented your home yet, right? Like, at Christmas time, you hadn't moved into the home, you were still in a very small apartment, is that right?
I wasn't in a small, I was in a home, but it was my cousin's home.
Right, you were
Yeah.
staying in a room at your cousin's house at Christmas last year, right?
Yes.
But you did have the kids on Christmas Eve, right?
I had them for a portion of the day, yeah.
Okay.
But my point about that was just that, you know, their comfort zone is Queen Lake. And it's way different when you're trying to, you know, shift in a rented room for Christmas.
Now, at the time you married, did you have an obligation of alimony to your prior wife?
Yes,
When was your divorce from her finalized? Actually, I think that the decree and separation agreements are in evidence, so I don't have to ask you that question. What was your alimony obligation to your ex-wife at the time you married?
it was variable because I was paid on incentive. So I had a base salary, so there was a certain percentage that came out of the base, and then a certain percentage that came out of the variable income, like commission and bonus. And they were not the same percentages.
And what was the base amount of alimony that you had to pay?
Geez, you know, you're asking me something that goes back a few years and I've wanted to forget.
I'm pretty sure you remember the exact.
No, I don't remember the exact
Number.
amount, but I might be able to find it for you.
He wants to get it.
Yeah, it's
I know,
actually.
I know I know it's in these
It's on the
documents
separation
somewhere.
agreement, we can do
No,
that.
it's okay.
Yeah.
So the
It was
base-
10% of my base salary.
Okay. And the variable amount, how much percentage of the income above your base salary did you have to pay?
Yeah, I'm sorry, I take that back. It was 30% of my base salary and 10% of my incentive income,
Got it.
okay? So depending upon what that ended up.
And for what duration?
Well, that was in Connecticut. That was,
Good night, Snoopy.
As long as I
Thank
work.
you.
Okay.
Feel better.
This one you probably do know. When was your last alimony payment to your wife?
when I stopped working. So
So
that was
2020, 2021?
2000, probably 2021, maybe mid-year. May.
And your Social Security, the Social Security receipt is deposited into the joint account?
In the transaction account.
I'll identify it by number just so we don't have that.
6857.
6857.
Right.
And while you were working for Element 115 and then later for the purchaser as a consultant, your paychecks went into the joint account, correct?
Into 6857.
Is that a joint account, sir?
Yeah, it was set up originally, as I spoke to you about, that it was set up based on that immigration point.
Now, the document that talks about the immigration things you should do, it says open a joint account. You have 4 joint accounts, right?
Not at that time.
Do you have 4 joint accounts now?
Yes.
Thank you.
I don't think I can hang out the bottom of the screen today because this site, this channel is so professional, and what happens is they give you tidbits down here that pop up, and you're gonna miss them if my face is covering it.
The deductible on the insurance, are you able to get a better standalone policy for the kids, for just the kids? That would be,
I haven't done the taken responsibility for that. I'm on Medicare, and I cannot include the kids on Medicare.
right. But I mean, as far as finding something that doesn't have a $17,000 a year deductible, is that something you'd be willing to explore?
We've talked about it, yeah, I mean, I'm open to, but the problem is, it's what's offered through this Obamacare in Nevada,
When did you move to Nevada?
2010.
On your financial disclosure form, it says you have, and you talked briefly about it, you paid your attorney $51,639 to date as of December 7th, is that right?
That's correct, if that's what it says.
And it says
Thank
that
you,
your
Donna.
current balance owed
Roughness.
as of December
Ouch.
7 was $7,665. Is that through November, meaning you got November's bill and that was the balance through November?
I'm not sure what date it takes me through, but I did pay that.
Oh, so you paid that as well?
I put that on a credit card.
So at this point, you've paid roughly $59,300 to Mr. Keller's firm?
If that's what you totaled up.
Well, I'm just adding 51,639 to 7,665. How much did you pay the Draskovich firm for the criminal case?
I would have to look that up, but it was probably, I don't know, maybe 10,000. I don't remember the amount. I know that it's in documentation that I've submitted previously, so I'll tell you right now.
Now, from 2008, when you got married, to 2020, did you contribute to the Element 115 401k plan?
Yes.
And I know we talked about this at your deposition the other day, but when we talked about the Fidelity IRA rollover 0263, we talked in terms of that was likely where the 401k from Element got rolled over to.
That is.
And is that a true statement?
Yes.
Because when I looked, and this is by no means an attempt to trick you. I want to make sure that we have the right understanding, because it seems a little different than what we discussed at your deposition. So
Thank you. I love Bloody Marys so much.
it identifies that Fidelity 0263 IRA as having a premarital balance of $220,000.
Okay.
Then you have 401k American funds for Element 115 with only a $6,092 balance, which would make sense because the company was fairly new at the time of marriage. Is that right?
Right.
Okay. So my question is, and I'm hoping you have an answer, and because it may be something that we don't have a true answer on, is would you have been contributing the maximum you could to your 401k with Element 115?
It probably varied. I don't think I was at the max at all time, because sometimes we just had cash flow issues and needed it.
And do you know how much was rolled over from Element 115 401k into the current iteration of Fidelity IRA rollover 0263?
Well, it lists the Element 115 as, what institution was that?
American funds at the time of the
Okay,
creation.
so, and then it changed, so I think it changed once, and then it changed again. I think it went to Fidelity, if I'm not mistaken. But it would have rolled over. I would have, to best of my memory, I did roll it over, but I also had taken money out of my IRA account.
Your Fidelity 0263?
Yeah.
When did you do that? That makes a lot of sense now. Do you know when you took the money out of that IRA?
Well, I took it out to buy the house, the Legacy Island house,
Okay.
because I hadn't sold the one in Clarksona at Winona Road.
Okay, so let me ask you this. since that explanation makes a lot of sense, do you believe that a majority of the 0263 IRA rollover at Fidelity is comprised of the Element 115 401k?
Do I believe the majority of it is?
Correct.
I can't honestly answer that question. I would have to go back and research records.
Yeah, because in looking at the massive volumes that we've already discussed, I didn't see any evidence of what the balance in your 401k is when you left the company, which is what would trigger a rollover event, right?
Mm-hmm.
Meaning you're no longer with Element 115, 401k has to go somewhere else, you roll it over.
Yeah, I mean, I'm sure that I could dig up records on that, and I think I did last time.
No, and you know what? Maybe they were in there. I just didn't see them when I prepared.
I think I tracked a lot of that because there were a number of things that manifested movement of accounts. One was the divorce with Linda, when the money was split up, and it was mix and match with different IRAs or 401ks because I had been with a few companies, and you know, some of it I used for some of these payments, down payments. Some of it got put back. And I think I tracked that down for that first
Okay.
hearing.
At the time of the prenup, you knew what the alimony obligation you
Are you playing music yet?
had was going to be?
Yeah.
Other than the variability of the 10% of anything above your base salary?
There was a divorce decree, and it was in there, yes.
Is there a reason that in the liability section of the premarital agreement, you didn't list your alimony obligation?
Just going to object, Your Honor, that's going to happen. You already addressed that at the first.
Understood, but it's overruled. The question may be probed.
Yeah, I think we did talk about that, but
I was just wondering if there's a reason you knew.
that I knew? Well, I did list an obligation to Linda at the time.
Roughly $8,000.
Yeah,
Which?
but what was I supposed to put? You know, if I have a monthly obligation, and I don't know when it's going to end, what am I supposed to put? I listed what I owed Linda.
And do you, I mean, we have your tax returns and evidence, but do you roughly know what your base salary was in 2008?
2008, it was probably $72,000 a year.
And your alimony obligation was characterized as terminating upon your secession from employment or retirement, or were those the words used?
I'm not sure what the words were used, but I think you have the divorce decree, but I do believe it was, you know, on stopping work, in essence. I don't know if those are the words.
Okay. And you believe, regardless of whether or not you contributed to the 401k with Element 115, that, you know, during marriage, that is, that what is contained in the IRA rollover right now, you're saying is 100% your separate property?
It's in my name.
So you're saying that because it's in your name alone,
Mhm.
it's your separate property?
That's what I understand to be true.
Okay. And is that the same for the 3 accounts that contain the sale of the Element 115 company?
Yes.
Working for your company, do you recall how much she earned?
She worked there for about 5 years, so I don't remember every year.
Do you remember what the most she earned when we're
You have to imagine that the mother's name is just a horrible swear word. So every time that he says it nonchalantly and it beeps, he's calling her a or the father's name too. It's just a horrible swear word. Trust me, it makes this more funny.
working for your
Well, she probably earned between 30,000 and 65,000.
But that would all be on tax returns that are already in evidence, right?
Yeah. Yep.
I don't have any further questions, John.
Just very briefly, Your Honor, if you can go to your prenuptial agreement, which is that exhibit H again,
Okay.
you go to base stamp 734.
Okay.
Does it, is your element 115 401K listed as a list on your separate property? Is it listed the 401K?
Yes.
Okay, so not only is it listed, let me strike it. Okay. And again, just going down below onto this big stamp 734, Linda, you have a number for $8,150 that was owed to her as of 5/18/2008. Do you see that?
Yes.
Okay, all right. Do you, what belief, if any, do you have that by listing your 401K and element 115 as your separate property, what was your belief as to what it would, if a divorce occurred, what did you believe would happen with your 401K?
Well, I believed what the language says in here, that it was under my name and it would be retained as my account.
You were asked about your tax return. I'm going to just approach with Exhibit 90, which is your 2008 tax return. So, there wouldn't be any, it's your exhibit. Right?
Yeah.
All right.
Which exhibit number is this?
It's Exhibit 90. So this is before you got married, right?
2008? No, this would have been after.
Okay. It's a joint return, is that right?
Yeah, it's a joint return.
Okay. And the total amount of income at that time
Kelly,
was
that's stupid.
$144,811.
That's correct.
All right.
That's, yeah.
Okay.
I don't know if that's all income, it could be,
Or I'm just saying the total amount that he asked you what,
yeah,
some of that might have been investments as well.
yeah.
All right. I don't think further, Your Honor.
All right,
No?
all right, you may step down. Does that conclude the
Evidence portion of
evidence
these
portion?
proceedings?
Yes.
I believe so.
I did want to, just some follow-up questions, just so I understand exactly where we're at. And then I do want to have some limited oral closing statements. I'm open to some written submissions. You can have that discussion as well. I'm going to step off because I'm going to give you some direction. I want to give you some time to gather some thoughts perhaps and talk to your clients, because I have some specific instructions to give as to what I'm looking for in oral closing statements, and I do want to hear from both sides about your appetite for anything in writing, whether it's proposed findings or a...
Well, and I'd like to have an
Hey,
opportunity to review the case that you provided
Understood.
today.
Well, and it's either proposed findings or page-limited
And I'm fine. I'm fine
closing
with
statements. So I want to hear from both, but I did want to touch up on this retirement plan issue, just a brief follow-up. And understand, I'm going to be looking at the case law as well. It appears I may need to do some legal research. I know from our most recent hearings that the issue of property, as much as I had hoped that I'd put that to rest with my decision on the premarital agreement, was done. I understand there's some legal issues I need to look at. And so I'm not in a position to I have no inclination as I sit here today as to exactly how I'm approaching those issues. I want both sides to be clear in that regard. I need to do the legal research. I obviously will be reading the premarital agreement again. I did not read it in preparation for today. I know there are portions that were cited. There's reference to these retirement panel plans being specifically included as part of the premarital agreement. What I don't recall from the premarital agreement, and maybe you have that at your fingertips, is whether it also includes language that states that contributions made after the marriage were covered by, is there an argument that they were covered by the premarital agreement? I understand the accounts were identified, but it goes to the notion of contributions being made during the marriage, and do you believe that's covered by the premarital agreement?
Do you want me to answer it, or?
Yeah, go ahead and answer it.
Sure, I'll be very brief, well, maybe not that brief, but, it's very clear that when the court made its findings in this case on the premarital agreement, one of the things that the court noted was that the premarital agreement was printed off the internet, and that.
Right, it was a form, it was,
Right,
yeah.
and that it contained boilerplate provisions that didn't seem unusual or peculiar in any way, shape, or form. Very plainly, the language in that prenuptial agreement that was printed is basically the language they use, just like here in Nevada, we see the same language over and over and over again in prenups, no matter who drafts the prenup. I have a case that I've cited to you on this very issue, and the argument in that case, and it follows 13 other cases that deal with this very issue, is that if it says in the prenup that, in Pennsylvania, that unless your name's on it, right, that you have no entitlement to it. If your name's not on it, you have no entitlement to it. No percentages, no nothing in any way, shape, or form. And in this case that I cited to you, Donna S. Gartner, what happened in that case was husband was on his second wife. There's a prenuptial agreement. By the way, it's a 2023 case. There is an IRA account which is not even identified in the prenuptial agreement, so it didn't even mention this IRA account. It had a beneficiary that was on the account that was not the second wife, right? The husband dies. The second wife comes in and says, well, there's no beneficiary on this account because the person that was on that account had also predeceased. And therefore, I should get the account because I was still married to him, and it's not mentioned in the prenuptial agreement. And the prenuptial agreement is therefore ambiguous. And what the Pennsylvania court said very succinctly, and it uses the same language that we're talking about there, it's boilerplate language, is that if it says in the prenuptial agreement that unless your name is on it, right, whoever's name is on it, that's who owns it. So unless your name is on it, even though, right, he died during, while you're still married, and even though the prenuptial, the IRA account was not listed in the prenup, your name was not on the account. And it's not ambiguous. These terms in Pennsylvania are not ambiguous.
But listen, retirement accounts, I will say this, I don't know that I've ever seen a retirement account that has joint names. I don't think you can.
Well, she wasn't listed as a beneficiary.
Well, but that's different than titling. Retirement accounts
Right.
inherently are individual accounts, and so I would not anticipate there would ever be a joint name on a retirement account. My question is more in the nature of, does the premarital agreement itself state that, for example, and again, I know that it was this boilerplate form, and
Well, it's
it
right
was
here,
something
Ron.
that was, is there something that says income earned during the marriage is separate property and not marital property?
There is no
Actually.
such recitation.
If you look at page 3, paragraph 7, it does have such a recitation.
It references income being separate property.
It says, during the course of the marriage, all property acquired by each party in their own name shall be deemed to be part of the separate estate, and by the terms hereof, each party hereby waives and relinquishes all claim to the separate estate of others. Likewise, all property acquired during the marriage in the joint name of parties shall be deemed to be part of their joint estates, and thereby evidence their intent to grant the powers and rights to parties to be jointly owned. And what we're saying, Your Honor, is simply this, is that all of this was gained in his name titled in his name alone and under Pennsylvania law, which is not a community property state. It's not a community
Well, I
property
know,
state.
and therefore I asked the question, separate versus marital property, because it's a
Right,
marital
right,
property
yeah.
estate. And so, again, this goes to where
Well-
I may need to do some research and,
And Judge, that's also why, and I understand, if you wanna hear limited oral argument, I'm, I'm never shy about standing up and arguing, but, I do want to reflect on the exhibits that are in about this issue of tracing, because I think your question is 100% right, and that's the question that I have, okay? There is nothing in this agreement that says the earnings of each spouse are their sole and separate property after marriage. That's what you were looking for, nowhere in there. Okay, very much in the same reason I make the argument. There's nothing in there that talks about the appreciation on businesses or separate property, et cetera. It doesn't even have it has the rents, profits, et cetera. It doesn't say appreciation anywhere. So, I mean, again, when you have, in my opinion, flawed documents, regardless of the fact that you've already
You're asking the wrong person. Because I watch the crappiest audio video courts out of every channel. I struggle to get through. I should just move on to courts that have better audio. Nope, not me.
decided that which you decided as far as the undoing the duress issue and timing and the inability to review and all that, and omitted debts and things like that, you still have to construe it against the drafter. And like you asked about the retirement account issue, you know why you asked that question? Because I've done prenups with you a long time ago. Every prenup that any lawyer that we know has ever prepared has a specific, like, you have to have an extra initial.
I recorded it on a VHS, but it wasn't a brand new VHS. I think my wedding ceremony was on it or something, and I've already recorded over that like 100,000 times just to get rid of it. So this tape has been re-recorded over and over and over.
In the part that says, I'm giving away contributions to retirement accounts during the marriage. Okay? There is nothing in there. And because it doesn't say wages,
Or it was
are
porn.
separate
I can't
property,
remember.
right? And this idea that just because dollars ended up in an account just in my name, the prenup controls, I mean, under that theory, the parties could be out spelunking in a cave one day and find a $10 million diamond. They can sell it, and if it goes into an account in his name, under his theory of the prenup, that means it's his separate property. I think that's contrary to both Pennsylvania and Nevada law, but more importantly, if you're going to have a waiver of a very specific type of claim, it has to be in writing. In a prenup, particularly given the circumstances of this one. But I think the court's question, it probably does need some additional legal analysis. I know, yes, this is a new case. I haven't had a chance to read it, but I do note that it's only a Superior Court case. It's not the highest court in Pennsylvania. I'm sure I can find out between now and the time of submissions whether or not this is on appeal to the Supreme Court of Pennsylvania.
all right, so here's the direction I want in terms of your closing statements, and I'll step off, give you a few minutes, 10 minutes, 10, 15 minutes, I'll return. As part of your oral closing statements, I want to know.
You use sticky tape instead of the not sticky tape. He doesn't need to use sticky tape. It's our. Never mind.
Know exactly, in terms of numbers, what you're asking the court to do. In terms of child support and spousal support. The property issues are a separate, and certainly I'm not precluding you from making arguments regarding the property issues, but that's something I've got to dissect separately, and so certainly I'll receive arguments, but I want to know exactly what you're asking the court to do in terms of numbers. Now, the defendant did offer some testimony in that regard based on a prior deposition. I think he was trying to recall, and he mentioned 1,500 and a total of 3,000. So I know there's a number out there. Plaintiff did not offer, I know she was pressed for a number by
But
Mr.
Judge,
Keller.
what she said was, it all depends on what property I receive.
Well,
And if put it to you this way, if he's successful in all of his legal arguments, resulting in her getting $0, meaning $0 after a 15-year marriage with 3 children, that's basically the position he's taking.
Well, listen, and it
And if
works.
that happens, the amount of alimony is gonna be this big.
Well, listen, and it works both ways, because the testimony also established, and rightfully so, that if there is an apportionment, if I ultimately determine, okay, looking at the assets, there is some apportionment that should be made,
It's
then
gonna
that's going to
reduce
affect his income.
100%.
And so I understand there's an interplay here, but I still want to know numbers. And I mentioned at the outset, certainly lump sum alimony is something I can consider, but I also recognize if I went down that path, it affects the pool of income that might be available. I still want to know, and you can couch it in those terms that,
Right.
in terms of this is the amount we're looking for. It should take into account this issue. It's my understanding it's $885 per child in terms of Social Security. How that interplays with the child support, is that part of the amount you're asking for, or how are you proposing that we divide that, given the fact that the parties have joint legal and joint physical custody, or is that part of your number? So I want some understanding from both, a specific number from both sides in that regard. And then also, the second part that I want to hear about is I have delayed for months and months the transition. I know the defendant has been asking since the beginning of this case to return to the residence. The plaintiff has indicated she has no problem. She's claiming an interest in the residence, but is not looking to stay there. It's not a situation where she would be refinancing to buy out the defendant's interest.
But it's so professional. Are you kidding me? It's so good.
I presume that ultimately, if I did find that there was some type of a community interest to be divided, and that's something I need to look at, that the defendant would still like to keep the residence
Yes.
and buy out that equity.
And because she can't qualify to refinance it.
Well, I will
she
say,
understands he would be the one to receive
right,
it.
and I'm assuming the defendant does not want to sell that property. Is that a fair assessment?
Correct.
So I know there was an opinion offered regarding the value, but I have no appraisal. I have no idea what the value is. So that is somewhat of a moving target. And again, it fits into this entire exploration I need to do as to whether there's a community property interest. It's my understanding there's an audio recording out there that I will be listening to that's been admitted into the record. So I do want to know in that regard how.
If one person says they don't remember, I'm going to replay it right now. It's going to take one person.
However, in terms of the timing of events, and this is perhaps more on plaintiff's side, I know the defendant wants to get in yesterday.
I understand.
And so it's really a timeline to make that move out. There is this rental property, it's my understanding, it's on a month-to-month lease that he has proposed that plaintiff can move into. That certainly is an option. I want to hear from plaintiff's side the position and when we can make that transition. Understanding, I'll take it under advisement. It may take some time, and I still need expenses paid for. Also, when you're talking in terms of the number you're presenting to me for alimony, I'm somewhat backtracking. As you're aware, one thing I'm required to consider when I'm looking at the issue of alimony is the case law precedent talks about the standard of living. That's one of the specific factors I'm required to look at is how do I define your standard of living? Really, what I look at are your financial disclosure forms. And I will examine every financial disclosure form you filed in this case. So part of that is when I look at your expenses, you're defining for me what your standard of living is. And sometimes when I see an expense that jumps out of the page, and I take a second look and say, wait a second, is that really the amount?
That's
Then I say, okay, what you're telling me is that is our standard of living. When I look at your food expenses, you're defining for me, you're saying, Judge Duckworth, this is our standard of living. This is what we buy on groceries and dining out on a monthly basis. And so you cannot logically or rationally expect me to say that the other party should not maintain the same standard of living. So keep that in mind as you're looking at the number you're going to give me, is I'm defining your standard of living by the expenses you're telling me is your standard of living. And to that point, you can't criticize the other party's expense on that same expenditure if it's lower than yours. Because you have similar households. It's each of you, and you have joint physical custody of your 3 children. And so keep that in mind. One last point too, that I do need some follow-up on. We get into this whole debt issue, and I'm going to be looking at your financial disclosure forms initially, what the debts were at that time, what they are now. Has there been a spend up? I don't know if in the volumes of exhibits that I'm going to be perusing, it has statements that show what the balances were when the divorce
Yes.
started versus the balances today, because that's something I'm certainly interested in looking at in terms of defining what, how I may apportion that. So take that to thought. 15 minutes enough time?
More than
15 a month.
10, or you want 10?
To
To gather your thoughts, to
10
start,
to gather thoughts. How many minutes are we arguing?
10 minutes aside.
Go red.
Okay?
10?
My bank account is always red. I don't know what that
We're
means.
back on the record in the Wonky matter. We'll now proceed with 10-minute closing statements on each side. So, Mr. Jones, you may
Thank you, Judge. I'm sure you were shocked to hear I welcomed 10 minutes.
10 minutes.
I do have a Supreme Court brief deadline tomorrow, so I have more work to do other than this case. But we discussed the prenup issues, and obviously I recognize as plaintiff's counsel that that's going to be an issue of law that this court decides. But it can't be ignored that general terms cannot consume specific waivers of specific claims, not assets, but claims to appreciation on assets, et cetera, so on. Also, I think your court's going to conclude that Nevada law applies to the marital residence. My anticipation would be that we would also submit sort of a memorandum of the legal issues along with proposed findings. Don't know what timeline you want. I'd probably prefer at least the end of the first week of January to do that. If you want that submitted sooner, obviously I can make that happen. Because the legal issues kind of direct everything else. On the alimony issue, the one thing I think the best testimony on that was my client saying, I can't say because I don't know what I'm going to get property-wise. Because one position is she gets $0, and one position is that she gets significant dollars. And those dollars that we're talking about are not the items that he inherited. They are not.
I don't know why the camera doesn't show the color as red. It really is red. I don't know why. I just don't understand. But that's fine.
Those things specifically listed as inherited, but the court, and in the findings, the proposed findings, I would suggest that I point to you where in the massive stack of documents you can find the references to whatever information we
It reminds me of J.G. Wentworth. I can't stop singing that stupid song in my head. 877 cash now.
have with how much was in the 401k at the time it was rolled over, as far as the contributions, because I don't even know that number yet, and unfortunately, I don't think we got an answer to that, to find out what's at play. If he said he consumed a large portion of the IRA that was premarital.
I don't know what the camera will do with black hair. It barely shows red. I don't know how black is going to look on the camera. I actually don't care. My color choice depends on how expensive. If there's a color on sale, that's what color I am.
And I don't know that I have sufficient documents, and I'll suggest to you that in my brief and or findings, if there aren't sufficient documents in any of our binders, I'll point that out, that might be something the court has to defer the amount on. You can still make the legal decision. If the legal decision is, no, it's all his separate property, then obviously that's not important. But the IRA rollover, we believe, has a large component, if not all, community property. The sale of element 115, you know the position on that, that's a community property asset as it pertains to the appreciation. And just so we're clear, because I know what the implication was, while Anthem testified that based upon those numbers, 1.4, right, would be the community property portion of the 1.7 sales proceeds. Nobody over here is going to say that he owes half of 1.4 when the community has consumed a portion of that. Meaning, we now know that the proceeds remaining are about 1.3. So if we know the sales price was 1.7, we can figure out the percentage. So 1.4 is roughly, I didn't do the math, but I'm going to say 78 or 79% of 1.7. Could be closer to 60 something. But I think it makes sense to extrapolate that onto the remaining balances because there is no dispute that some portion of proceeds have been consumed throughout the
Do not extrapolate that onto anything here. This is a courtroom, sir.
marriage. So if we look at the existing accounts as they are, at roughly 1.3, we know that that's a lower percentage of 1.7, so it's $400,000 less than 1.7. So likely the amount of community interest is about $1 million, as 400,000 has been consumed.
$1 million.
That is a logical approach to the mathematics. Once you get past the legal issue, and obviously I'll be happy to spell out the exact amounts that I believe would be appropriate, but you understand the theory that since we've consumed, and you could even take the approach, Your Honor, because I believe it's intellectually honest to suggest this, you could say, well, okay, so if 300,000 of the sales proceeds were absolutely separate property, and we consumed 400,000, then the remaining balance, we would have consumed the community portion and not the separate portion. I mean, I think you have the discretion to do that math and say the court decides that the dollars consumed would represent, so his separate property reduction or amount would not be reduced. So if you agree with Anthem's calculation that 300,000 and change is the separate property component, we would obviously say you could take 300,000 out of the 1.2 with the remaining being divided equally, which would be about 450 aside. Proceeds of the sale of the house, that approach, I believe, all the dollars came from the community, the joint account, no matter how much it gets characterized as account for immigration purposes, 4 accounts for immigration purposes, and immigration was over, the better part of a decade ago, so 8 years ago, but we kept these accounts, all 4 of them, for the purpose of making sure no one thought our 15-year marriage was a fraud. Some of the approach, I think, of the
Jen, I'm so sorry. I know that's great news, but I'm so sorry. That must be terrifying.
defendant ignores sort of common sense. But and then obviously the joint accounts, they're nominal. The cars, there's not really a dispute over. And those are really the only assets that she has a claim for property-wise. On child support,
Yeah.
we talked about what was probably a fair or reasonable approach. And again, the difficulty is if you give her lump sum alimony, or if you give her any of these dollars, we won't know how much his income would be. So meaning child support might have to be, you can run the formula amount based upon his FDF income, right? Obviously, I think the parties should equally share in the Social Security. So they would each get half of the Social Security that the children are entitled to, and then his income would make up what the base amount of child support would be above that, based upon the formula. And I think that of all the different ways you can do it, I think that's probably the fairest and makes the most sense. And then obviously, on the issue of alimony, as I said, my client's testimony that I have no idea how much I should ask for because I don't know what property I'm going to receive. That's going to be the reality. If you decide she gets $500,000, you can attribute an income to her. You can say that will cover her for this period of time. That will cover her for however long the court determines. If you find she's entitled to more from a property standpoint, obviously she recognizes not just because her lawyer thinks so, that at a certain point, if she has enough of those dollars, given the fact that he's retired, and the award of the dollars would reduce his income such that the child support amount plus the Social Security would probably be a reasonable amount of support, that she wouldn't be asking for any alimony beyond that. On the little interim issues, okay, I have a suggestion on that. And this isn't really a closing argument, but one of the things that, she understands his desire to wake up Christmas morning with the kids and in his house. Moving in the next 2 or 3 weeks would make no sense. She does not like his house. She would never live in that house because of the condition that she perceives it's in. And so what she would suggest for Christmas is she would have Christmas Eve like he had last year. He would get the kids Christmas Eve evening, and she would go stay in a hotel Christmas Eve night. He could stay in the house, obviously with the expectation that he won't be rifling through her things and that kind of stuff. I don't anticipate that type of behavior, but she would vacate for the Christmas aspect. And then your decision, I believe, would probably come within a reasonable period of time after the holiday season, which then could say, okay, here's how we're going to handle the transition, the moving. Because the problem you have is, because of her credit, she can't sign a lease. She'll never qualify. And I'm sure he'd be willing to co-sign for her, maybe. Or there would have to be an allocation. Usually, most landlords, my experience in these types of cases, if you pay 6 months in advance of rent up front, they'll rent to pretty much anybody. So that's going to be something that she wants the opportunity to find a place. She wants to find a place closer to the kids' schools because it reduces her primary shuttle service, and that's in the best interest of the children. So that's how we propose this temporary interim issue. Other financial issues on the interim, I know you already said he's going to continue to maintain the expenses. I just found out today, or I guess I probably found out when I got his FTF, that Mr. Keller's firm's been paid
Fozzie is always here.
$30,000 more than my firm has been paid in the interim. I'd asked for fees every time I've come to court, and I think you probably didn't know that Mr. Keller was getting his bill paid every month, whereas my client's accruing. And one of the big issues we have is, yes, the copy charges, the deposition fees, there's a lot of hard costs that she has $0 to pay. I mean, I guess what she could have done is go into the joint account and just, use the debit card and pay her attorney. I think she was concerned about doing that for setting up her husband. So the lifestyle, you made a good comment, Judge. His lifestyle analysis is that to maintain the 2 households is $26,000. Her FDF, which endeavors to set a reasonable lifestyle going forward, puts her expenses at less than, I think, closer to 75% of half of that, meaning her expenses are in the $9,000 to $10,000 range, including kid expenses, some of which might be part of his analysis that if he's paying them wouldn't be part of her analysis, but her FDF that's about $8,800, and again,
Fozzie's always here.
$1,400 a month of that is deductibles for medical, and that's why I think one of the things the court should order is that the parties have to meet and confer and get a better health care plan for the children. She knows she's going to have to get her own policy for herself post-divorce, and that obviously is one thing that's not on the FDF because we don't know what that's going to, how everything is going to turn out with the property as far as that's concerned. But in the interim, if he wants to be in the house with the kids for Christmas morning, she's got no issue with that. If his proposal is she needs to move out sometime now, between now and beginning of January, there's a big problem with that. Nobody moves at the holidays. It would be irresponsible of him to ask for that. It would be contrary to the children's best interest, and it would probably be impossible to do. But she understands that she will be moving at some point, but there's a lot that needs to be done for her to be able to find a place that she thinks is best for the kids, closer to their school, and that's sort of the only housekeeping issues. So from the standpoint of what the court asked for and trying to stay close to 10 minutes, you know what the property claims are. You understand what I think is a reasonable approach to the child support issue, given the Social Security flowing. You know that alimony, if she's blanked on a 15-year marriage with 3 children and ends up with 0 property, I think you know that's probably going to be the single biggest factor when you calculate, looking at the lifestyle, how much she would receive in alimony per month. Call it $6,000, call it $5,000, and it's a 15-year marriage.
I married wrong, guys. I married way, way, way wrong. What do you mean $6,000 in alimony a month? I didn't even get $600 for child support for 3 kids in a month. How is she getting that much alimony? I don't get it. I think I would have had to pay alimony if we went that direction because he didn't work and I did.
You're looking at 7.5 years, probably minimum in alimony. So even if you went 5,000, 60,000 a year for 7.5 years is close to $500,000. Now,
$500,000 to get divorced?
For that, but
Gosh.
those are the ranges of lump sum alimony that you have to get to if
Anybody want to get married to me? Anybody want to marry me? I'm ready. I just got some information that makes me interested in marriage again.
she receives no property, so that you would be able to satisfy your concern about the marital lifestyle.
Okay, just one brief follow-up question, then I'll hear from Mr. Kelleher. The legal argument regarding the court's approach to assets.
Come on, John, divorce is fun.
And it goes back to what I started with when I started trial. Is your legal argument any different, ignoring completely the existence of the premarital agreement? Throw the premarital agreement out the window. Is your argument any different?
It's not really.
It's okay, and that's
I'm in.
the argument is that the premarital agreement is an irrelevant legal.
It turns out, here's the thing. When the premarital agreement was challenged, it was based upon the circumstances under which it was obtained, which I found to be unconscionable. Obviously, you disagreed with me legally, which is fine. What we didn't know...
I will promise you I will not take any animals. None. Zero. Did you know that a clause is unconscionable when equal bargaining power between the parties exists or the clause is not really ascertainable? There you go. I read to you guys.
At that time was that the position that he was going to take is that these terms that don't mention appreciation on the business, don't mention anything like Malmquist or the equivalent, don't mention earnings being separate property during marriage. I didn't know his position was going to be she's entitled to absolutely nothing.
Well, again, I just...
So obviously, had I known that was the position on minute 1 of the case, I probably would have couched the challenge to the prenup as also being declaratory relief. So you could say, okay, I'm going to say it's enforceable, but I'm going to say that these provisions don't cover retirement benefits. These provisions don't cover this type of thing because she doesn't have any control over whether the 401...
I didn't say I read it correctly. I just said I read. I can't see. My eye can't see anything.
case not her name. You made that comment.
Well, listen, I understand, and there's some 2020 retrospect
I understand.
going into it, but it leaves the impression for the court that all of that energy, time, resources, money that the...
CJ, you knit or you crochet the dress, and I'll crochet the under the dress.
parties have
The
spent,
unmentionables.
and time of the court taking it under advisement, issuing a decision was
Well,
a waste of time.
it wouldn't have been if you would have decided that someone who is pregnant and flies from another country to get
Listen.
married and is presented a prenup on the day of the marriage with no chance to have it reviewed by attorney, if you would have, and listen, I understand that everybody can have a different approach to those issues, okay? And maybe you and I viewed the facts differently, but that doesn't make the challenge, You can't say it was a bad faith challenge. You didn't say it was a bad
No,
faith
no,
challenge.
listen, and I still don't today. I don't, listen, I don't question
They're
that
getting
entire process.
divorced.
But legally,
And
it may
there's,
turn out to
and
not
I,
matter.
and hopefully I made it clear in that decision.
Right.
My view of that premarital agreement is much different. In fact, I don't think we even have an evidentiary hearing if I'm applying Nevada law to that premarital agreement.
Oh, sure.
It's not happening. Pennsylvania has some very unique approaches to premarital agreements that are unheard of here.
Right.
And so, to that extent, I think there would be no consideration of a premarital agreement had I been applying Nevada law. Just the
I understand.
timing alone, I have issues with. But under Pennsylvania law, look, that was clear as day in terms of that precedent. Now, I don't want to go back, and I'm not here to revisit that. I want to make sure I understand the argument. Let me hear from Mr. Keller.
Thank you.
And Mr. deeply appreciates the court's time, as does Christine and myself, work on this case. First off, let's be really clear about the prenuptial agreement and what our position was. From day one, with her first set of lawyers through her second set of lawyers, we've made it very clear that my client was amenable to paying alimony and obviously child support, paying child support as well. No issue there. We made it abundantly clear from day one that she had no interest in element 115, and she had no interest in any of the real property, the one house that's owned here in Nevada. And I want to address, and I'll walk through, the court made a comment saying, well, her name can't be on a 401k because only the earning spouse can be on a 401k. Pennsylvania, their law says that what the prenup says, which is, and there's not just this case, there's multiple cases, that if the property or the account is in the name of that person, they own the account. No exceptions. Not whether you could put someone's name on it or not put someone's name on it. If the name is on it, that's who owns it, period. Pennsylvania is not a community property state. They don't have Malmquist. They don't have Pereira. They don't have Van Camp, which wasn't even addressed by the expert in this case in any way, shape, or form.
But we have really, really good chicken pot pie.
So what are we left with? We knew, they knew at the time that they got married, and the court found that both parties were in a difficult situation because my client, in fact, this was a finding that the court made, was in just as difficult a situation finding out that he had a pregnant woman who may have to go back to another country, and he was under as much pressure, if not more. In fact, that's an actual quote from your findings, so you can go back and look at what you found in the case. There was no mystery here. On the prenup, right, it lists element 115 fidelity account, and it's understood that he's working at element 115, and he's going to continue to work at element 115, and it lists element 115 and a value, and it's known that he's going to continue to own and work element 115. Those accounts have always been in his name. Nothing's ever changed. As to the house issue, Your Honor, you lose on two counts. One is they lived by this prenup. Every residence that was owned during the marriage was solely titled and solely loaned in my client's name, consistent with the prenup. Under Nevada law, which is not applicable in this case, and at the very outset there was a fight about what law should apply, and we never could get a concession from the other side that under Braddock, Pennsylvania law applied, and then you said Pennsylvania law applies. So I don't know why we're talking about all these other cases, right, when Pennsylvania law is the applicable law, and we cited to Your Honor very respectfully, as I did to both counsel that represented.
Bow down
opposing
before
party.
us.
At the very outset, if you look at our answer to the prenup complaint saying it's no good, I cited right to the applicable Pennsylvania law and alerted the attorneys there as to how Pennsylvania deals with prenups. So we never hid the ball, we didn't hide it. This is just another way to come around and claim that there's ambiguity when no ambiguity exists at all. In fact, the case, if you read it, and the 13 cases that it cites to going back, talk about whether the fact that someone says it's ambiguous doesn't make it ambiguous. It's not ambiguous. If the account's in your name, the property's in your name, game over. That's how they deal with it in Pennsylvania. But even if you apply Nevada law to the property here in Nevada, she signed a grant bargain sale deed, right? And under our law in Nevada, it's presumed, even if there were no prenup, the presumption is that she would have to overcome by clear and convincing evidence that there wasn't an intention for him to have the whole property, right? So even under Nevada law, that she'd have to overcome suspenders and a belt in this particular case. Having said that, Your Honor, I want to talk a little about somehow the court wanted to address this living standard. First off, Your Honor, she does have medical insurance. She's on the same medical insurance as the children. So they don't sell any insurance policies in Nevada just for children. You have to have a parent on there as well. So under Obamacare, it's all the kids, all 3 children and herself is on the policy. So she doesn't need a new policy. She's on the same policy. Having said how the parties lived, Your Honor, that was the complaint that my client made at the very beginning of the case 14 months ago when we came in. We told the court that he was hemorrhaging money, that her spending was out of control. And one of the irritants in the case, or one of the concerns in the case, and you heard some of that in the prenup hearing, was that he was very deeply concerned that he has limited funds, being retired and being, at that time, 73 years old and now 74 and a half years old, that this money was going to run out. So trying to use a number of $26,000 plus a month in expenses is catastrophic. It's going to send the parties into bankruptcy and this family into oblivion. You can't afford to pay that. And what we're explaining to the court was he's been paying, cutting a vein each month and going into his separate account, his separate money.
Hey, hi.
Element 115, right? And paying month after month to the tune of almost $400,000 less, a 67% reduction in that account over a 14-month period. During that same period, out of the transactional account, she has moved money into an account that is in joint names, but only she uses. $83,000 over the relevant time period. $83,000 went in there, and she spent $82,000 and change. And from what we can tell, none of it on attorney's fees. Fast food, Amazon Prime, videos, a whole slew of non-essential expenses, because the essential expenses, all the day-to-day stuff has been paid by my client. What my client understands and agrees to pay a lump sum alimony, Your Honor. What we're asking the court to do is to impute. You can do it one of 2 ways. You can impute an
Victoria, hey Victoria, hey Victoria. What's a pirate's favorite letter? Victoria, what's a pirate's favorite letter?
income to her for child support purposes. We ask that the court at least impute an income of $2,000 a month. It's barely over the minimum wage here in Nevada. She's only going to have the kids half the time, which we'll get to in a second. So we ask that it be $2,000 a month. My client makes the $10,566, and you saw the breakdown. We're asking the court that it comes out to a little less than $1,600. It's like $1,590. He's willing to just do, call it $1,600 a month in child support. He's also willing to pay a lump sum amount, Your Honor, of alimony, for a one-time deal to be done with it. Be $100,000.
A pirate's love is the sea, guys. It's the sea. R. Why would you say R? JK, thank you so much. That's so nice. Thank you.
Dollars that would be transferred to her in a lump sum. The advantage to that, of course, is that it would put some incentive to her to have this money and say, look, I can now, if I'm going to go and start yet another school, and that's been a concern for us, Your Honor, is that she's been in school, and then she drops that school, and then a few months before we come to trial, and that's only because we had continued the trial. She wasn't even in school, from what we can tell, before you continued it. And then after you continued it, now all of a sudden I'm on a tear to go to school, and I'm going to need another 2.5 years to supposedly get a degree. There's just not that kind of money coming in on a monthly basis. So we're asking the court to find that she'd be entitled to $100,000 in a lump sum alimony award, that she get $1,600 a month.
Yes, you got some good ones.
We're asking that the court find, that, as it did already, that the prenuptial agreement is fully 100% enforceable. And that obviously, when we read terms, we read them with the clear intent of the parties. And the clear intent of the parties is that the things would be kept separate. that whose name's on the accounts, those would be your
Make sure that you have gift memberships on. Make sure that it's turned on.
separate property amounts. It's also, it's very much understood that the vast bulk of the income during the marriage, the vast bulk, was earned by my client, and that he was paying all the expenses, which now is being held against him because, well, some of this money rolled through a joint account. Well, sure it did. But it went to pay all these various expenses, but the prenup says whatever the ultimate property is, that's your sole and separate property. And I don't know how much more clear it could be. I think when you read these cases, you're gonna see that these terms that the court identified as boilerplate or normal, they're the exactly word for word as what we have in this prenuptial agreement. And that's how they deal with it in Pennsylvania. Very respectfully, Your Honor, as to other issues, my client has waited and waited and waited. We originally came in and asked for an expedited trial date, which the court gave us on the prenup with the representation that once that's resolved on whether it's enforceable or not, game over. I mean, and the court noted that. So the court gave us a hearing date in March. My client went to a depot.
I shall keep you warm. I shall keep you warm.
He answered written discovery. He signed releases. There's tens of thousands of pages, I believe, of discovery. Everyone knew what his position was. And here we are all these months later. We're asking very respectfully, Your Honor, is that the court can just do a nesting situation, which means that right now she should move out of that house, take a few bags or makeup or whatever else, and move into where she's staying. The court.
Oh, hell no. No. Absolutely not. Nesting. Nesting. So the kids live there and the parents take turns coming over? No. Absolutely not. This lawyer is high.
Already toyed with that idea but didn't do it, and let my client move back into the marital residence and have this time, this Christmas with the kids, with the tree, and not be out the next following day. They know full well, Your Honor, that it's going to take the court, apparently we're number 10, so based on past stats, we're talking months. We're talking probably a number of months, and it's very unfair for him to be sitting out in a rental home after all these months as it is, when there's no question that he's going to be in that home, right? So we ask, Your Honor, that the court could make an immediate order that there be $100,000 in alimony paid to her. She can move into the house that my client's living in and take over that house. It's on a month-to-month, and then find some place that she's going to find suitable, right? If she finds, I mean, I don't know why she's saying it's so horrible over there. I don't know. Supposedly she went over there and cleaned it according to her own testimony. I have no idea. And he seems pretty neat. But anyway, for whatever reason, she don't want to live there. I don't know what that's all about. But having said that, Your Honor, they're going to have exactly equal custody. They've had joint custody all along. And none of this, Your Honor, is a surprise to her. At every hearing, the court had admonished and said, you never put her on a work search. We agree. The judge said, I'm not putting you on a work search. That would be you. But I am going to have to impute income to you. I'm going to have to look at that. And to wait until the 11th hour, literally, and then come in and say, okay, and now I'm going to go to school for another 3.5 years, and we still don't have a number from her. We could never get a number. Never. Like even today's date, we took her depot, no number. What is it that you want? Well, because when you look at what she wants, right, she wants exactly what the court identified. Throw out the prenup, whatever way you want to call it, you're throwing it out, but you avoid that and throw it out, just like their expert did. I paid no attention to the titles, and I paid no attention to the prenup. I gave them no weight whatsoever, and I didn't run Van Camp, which everyone in here knows is generally much more favorable to the separate property than the other property. We didn't run that because some purportedly undisclosed information wasn't available to us, but we never got what that was, and there isn't any. All the returns were there. His depot was there. Everyone knew what kind of work he did. We knew exactly what he made year after year.
You know where you can find the answer to these questions, guys? There's more parts to this. This is part 3 that I'm playing. Go to Our Nevada Judges, Inc. and look.
And for all of these years, even after the house has been, the business has been sold, he's been maintaining all of the expenses. And apparently, Your Honor, what we're sentencing him to is until the court can make a decision, there's going to be more months of him paying out what appears to be $26,000 a month. Like there's no economy, there's no like, hey, let me pull back here in any way. It's just spend, 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 and he wants it to end. And that's why we fought vociferously not to have the case continue these last number of months. So with that, Your Honor, we're asking that you allow him to move into the house on the 18th. She can move out. We're not asking her to move furniture and furnishings. We intend to be very liberal about how that goes about. And then, you know, obviously, we're asking that either the court make some orders to stop this flow of blood that's been going on for so long before there's no money really left. And unless the court has questions for me, Your Honor, that's what we're asking the court to consider. I would just leave you with this one, one thought. Pennsylvania is obviously, being from the East Coast, I believe it's almost 3,000 miles away. I know Massachusetts is 3,000 miles exactly. Having said that, they do things a little differently. And to try and now apply backwards a business that's already sold and was in your prenup listed as your own, and a 401k for the same business that you've been working at and was known at the time, and ignoring the fact that he had a lot of reasons to want a prenuptial agreement, including the fact that he had financial obligations to a former spouse, which she was aware of and testified about, and to children at the time. It's grossly unfair to now say, well, you can't have the benefit of that bargain at this point, and we're going to try and wrangle in some case law in Nevada from a community property state, which, by the way, that's not even our case law. That's California case law that we've adopted in Nevada that now we want to use for Pennsylvania prenup. And I leave you with also this, Ryan, even the Malmquist wouldn't apply in this case. The property is bought during the marriage. Malmquist has always historically applied when the house is purchased prior to the marriage and it's in one party's name.
Idaho, I might have something for you. I don't know. There's a pretty big murder trial happening in Idaho right now, and it's a 2-week long trial. I've gotten almost the first week now. So we'll see. If it's good, I'm going to condense it and show you Idaho.
And then payments made afterwards. There was an intent here, and the intent was for him to own it, and she signed a grant bargain and sale deed, and that's exactly what occurred. So with that, Your Honor, unless the court has specific questions,
The only question I have, the $1,600 in child support you mentioned, that's with the defendant also receiving the $885 per child.
My client would receive, right, we're basing it on, I'll just show you exactly what you were saying, $100,000 to her in lump sum alimony. Right. Then we're saying that pursuant to his FDF, which isn't in question, he makes $10,589. We're saying that if you impute either income to her, $2,000 a month, or if you took some of that $100,000 and imputed $2,000 to her, right? Because I know with alimony you're supposed to do that. Then his child support obligation would be like $1,500 and change. So this would be $1,600, slightly above that, $1,600.
But you've included that in that calculation, the $885 times 3.
Yes, absolutely, yes.
Okay.
Totally.
Just follow up on, because I do want to make temporary orders regarding what we're going to do temporarily while the matter is under advisement, and then set deadlines for the additional briefing. What about a nesting arrangement, Mr. Jones? That makes it, I will say, it simplifies matters certainly for me. Because we just maintain the same, where basically the children remain in the home, and it's the adults that relay back and forth.
So now we have to get 3 houses? One for the mother, one for the father, one for the children? 3 houses?
We go to a week-on, week-off schedule, and it's my understanding from the testimony in the record that both parties are on board with doing week-on, week-off with a Monday exchange date. And at least temporarily, we do a nesting arrangement where during Dad's week, he's in the residence, and during Mom's week, she's in the residence, and we use the rental. We use the rental for where the adult goes during the off week.
And it hadn't been brought.
So the parents are going to share the rental? They're going to just be okay with sharing this rental? Where do you keep your personal private stuff? Where do you put your boyfriend's toothbrush?
Brought up, but between now and
Right.
Obviously, I'd still want her to have some Christmas Eve time, and I think my proposal.
Well, I don't have a problem with, I don't have a problem with that. We can have some limited discussion in that
What
regard,
day is
but
Christmas this year?
it's Monday.
Oh,
It's
well,
a
that
week.
works.
So,
That works. Well, then, what we could say is she could stay in until Christmas Eve, then we would start his week on, week off Monday in the house on the evening of Christmas Eve, even though it's Sunday, and then we nest in and out every other Monday.
Well, what we're asking for, Your Honor, is simply this, is that this Monday you go in there and at least stay until after Christmas is over. If she wants Christmas Eve, she can have Christmas Eve with the kids at the rental house. The kids have slept there and been there, whatever else, but Christmas Day, she'll be with in
well,
the
but
house.
why not have him from a
I-
timing standpoint? We're here on.
I appreciate the beep. I appreciate the beep that this video gave me when I read this comment. Yes, yes, Sophie, you're right.
December 14th. I'd prefer to give him that entire week and say he comes in Christmas Eve that night. We can set a time, and he's there Christmas Eve through that entire week.
Because what he's saying, Ross, and again, given his age, right, I mean, he's in good shape, but he's, 74 and a half, is that it just is not favorable to him to have to move on Christmas Eve night, and you have bags and other stuff that need to be taken over.
He's bringing you a week's worth of stuff.
Yeah, this
It's a
is.
week's worth of stuff because we're nesting.
Well, listen, Ed, and it was your proposal to do the nesting, and I'm actually jumping on board that because I think it's a reasonable approach. I agree, but that was the offer that you had made is let's do nesting instead of getting into, because if I don't do nesting, then we're talking about, and I know ultimately the goal is to move out, and that's what I'm going to do. That's going to be part of the decision is plaintiff's going to move out, but then I'm looking at moving expenses and
You don't have enough money for her to move under your stairs.
monthly payments.
Rent.
It's easier for me if we just.
Well, and for the short period of time we're talking about, nesting is the thing that makes the most sense.
It's a reasonable approach, and I appreciate the offer on defendant's side. Now we're kind of caught up in exactly when do we start the nesting and what day.
Well, how about-
And I have no problem giving,
How about December 23rd and not the 24th?
But then she'd have zero. He had Christmas Eve last year. He even testified to that. Why would she get 0% of Christmas?
Well, but she's gonna have Christmas Eve, she'll have Christmas Eve on the 24th.
Right.
She'll just have it or whatever at the rental house, not at
So the house that he wants it to be so special with the children at, she doesn't get any part of Christmas.
listen, the goal of nesting and the value of it, which I emphasize, is a temporary solution.
Right.
And I don't do it very often, but in an opportunity like this, the beneficiary of nesting, ultimately,
It's the kids.
beneficiaries are the children. Plain and simple. I have a feeling that they share a connection with that home. That is home to them. I think they probably value I'm not undermining or undercutting the value they have with Dad at his place, but I think even he doesn't like the rental as much as the marital home. And so the value of nesting is the inconvenience is placed on the shoulders of
The
the
parents
adults
and not the children.
and not the children. Children stay put, and so I just assume they enjoy the entire Christmas season in their home. And we're defining when the two of you have the convenience or inconvenience of being in that home. And it's been clear to me, and the plaintiff has offered, Christmas Day is going to be Dad's Day in the home with the children, and they don't have to shuffle around. You two do.
Right. She'll have to
And-
pack a bag and move out.
Right,
by
I'm not
by 7
looking
on
at.
Christmas Eve, and then she would retake possession of the house the week following Christmas on Monday.
Well, that's what I'm inclined to do. We start doing a shifting, once school's back in session, this becomes perhaps a little more seamless, but it is truly a matter of just taking some personal belongings back and forth between the residences.
I'm sorry, the parties do have a parenting plan, though, that was a partial parenting plan for Christmas. And Christmas this year in 2023 is supposed to give him from the day that school gets out until the day after Christmas Day. So he's only asking, right, so he's only asking to do what the parties had actually agreed to in the parenting agreement that the court accepted. partial parenting agreement on way back when.
And my client has agreed to joint custody, even though the oldest child has only slept over at dad's 3 times the entire course of the
He's
case.
sleeping over, no, you're right, over the last number of weeks. he's been
It's,
sleeping over.
it's increased, I agree.
All I'm saying, Rob, is that they have an agreement in place as to Christmas, and we'd ask the court to honor that, because next year, it'll be honored for her, right? Next year, he'll be out of luck.
Listen, and I understand and appreciate that, but that parenting agreement, again, is independent of any discussion we're having regarding nesting.
No, I understand.
And that's where I could go down that path and say, well, the kids, they'll spend the first half of Christmas with dad at the rental. And that's, but I don't want to do that. I'm trying, I would rather put the children, and so it is different than the parenting plan.
Okay, you can just make the order on that. fine.
And that's what I'm gonna do. I'm trying, I guess.
All right,
I shouldn't,
So,
I shouldn't try and explain these
yeah,
things,
just
I should just order it and say, this is what we're gonna do. I'm
All
trying to apply some logic here, but listen, that's what we're gonna do.
okay.
And
And status quo financial orders, can she get an allocation of dollars to pay her lawyers?
I can't do that right now.
During the interim, he's paid his lawyers $30,000.
That's something I'll take a look
Not including
at.
criminal lawyers.
I'm not gonna make any orders today.
Okay, thank you.
So Mom will be in the residence until
7
Sunday
p.m.
night.
on the 24th.
Sunday night at 7 p.m. Dad comes over. You change locations. Dad has until the following Monday.
The first time my husband left me, I think we talked about nesting. Or, well, it sounded like me saying, please come home, please come home, please come home. That's nesting, right?
And then on the week on, week off.
And we'll do Mondays. Well, once they start school, we'll say 10 a.m. on Mondays if there's no school. But otherwise, you leave during the day after the children are gone to school, and then the parent who is going to be nesting that week will be in the home. The other parent should be gone by the time the children get out of school. And then the matter will be taken under advisement.
Timing for briefs. And the like.
Briefs, I know, Mr. Jones, you mentioned the first week of January, Mr. Kelleher.
Well, that's gonna be really soon for us, because like, how about if we made, well, and I'm sorry, I know I'm putting the court on, I'm not trying to put the court back. How long do you think it's gonna take for you to be, like, because what I'm saying is, not to you, we were gonna be out of town right after Christmas for a week in Florida, so we don't mind doing it, but if it's gonna
Oh,
be
he's
sitting around
nesting
anyway,
too.
and it's gonna be.
I don't have an objection.
You know what, and that's a fair point.
Tell me what your vacation schedule is, and
We won't be back, we're leaving December 24th, and we're gonna be back on, I think, January 2nd, the first week in January.
19 years. But 3 years of that were fake because 7 years after I got married, he left. My son was 8 months old. He didn't even leave a note. I put out a missing persons report on him. And he moved to Maryland with this girl he met online playing video games. And then he had a baby. And then he came back home. And in my defense, listen, the way I grew up, 12 years of Catholic school, is I can't get divorced. I can't. I wasn't allowed to get divorced. I had to work it out. We had to work it out. So I did what I was supposed to do. I worked it out. And then he stayed. So 7 years, then 3 years, and then he stayed that much longer. And then, I mean, he's cheated on me. He never stopped cheating on me. But then in 2016, when we finally got divorced, and it was great. It was a good divorce, and there was no money involved. John, I know you think divorce is all about money and marriage was all about money. It wasn't. There was no money involved in my divorce at all. It's just, do you want to get divorced? Hell yes, please. And we were divorced.
So you're thinking.
10 days after that? 12, 14 days?
That'd be fine, Rob, but if.
No, that's fair. No, that's fine.
So
that makes sense.
January 12th? I don't know.
Yeah, January 12th is a Friday. Is that
That'd be fine, Rob.
Okay.
January 12th? Now, do you want this to be in the form? I know Mr. Jones proposed submitting.
He had 2 kids in our marriage that were not mine. I went to Catholic school forever, and now I can't, well, I guess I could go to church, but no, I'm a divorced woman, so.
Proposed findings, conclusions, and orders Or do you prefer either way, Mr. Kelleher, or what's your
I'd
position?
rather just do a closing, we'll just point out whatever fact, because I know the court
Well,
wants to do its own.
I will
facts.
probably include in my brief proposed
People tried. I didn't
findings.
listen.
And that's fine.
That way, and I'll
You
send it to
format
you
it the
in
way
Word.
you want. 15 pages?
Yeah, that's, yeah.
Okay.
15 pages. I will say it'll be helpful if you can point to specific exhibits
Yeah.
in support of any argument you make, because I have a fortress of exhibits that
How do you
has
feel
come in.
about 18 pages? I don't have to have 20.
18's fine. 18's fine.
I think I would
I'll try to
rather.
keep it as brief as possible.
No, I
'cause
appreciate
I
that.
know about at page 12, you start losing interest.
What would I rather do than go to church? Taxes, dentist. I would rather go to a funeral than go back to church.
Right. Yeah. Okay, 18 pages. All right.
Thank you.
Thank
Thank
you
you very
your
much for your time. Have a great holiday since we won't see you.
Good job, our Nevada judges. Good job. Thank you for bringing us that. That was pretty good. I liked that. That was very professional. All that stuff to keep you busy while you're watching, and I've been thinking about that a lot. I've been thinking about putting little things on the screen, not words that you have to watch. Like I did it once before, but I had to delete that video. Um, a video game, match 3 video game was playing at the bottom of the screen while the court was going, so people could watch that. I've been thinking about doing that, but I don't know. TikTok. So here's the thing with TikTok, and no one knowing what's going to happen with TikTok and everything. People who watch TikTok, they watch videos like this, but also something is happening. So a rug is being cleaned. You know what I'm talking about? Where they clean the rugs, or a lawn is being mowed, or something, or a video game is playing down in the corner while people are watching the video, and it seems to. I don't know. I don't know. I don't know if it's more relaxing or whatever to have two things going at once, but. And I don't know where these people from TikTok are going to go after TikTok. Whatever happens to TikTok, I don't know. Thank you. Facebook, I'm gonna get Facebook going in a little bit. It's on my list. It's I haven't boosted the posts or anything yet. I'm working on it. Just not yet. I want to wait till there's some really good videos. Like, oh my gosh, videos. Like, Facebook has to see this video. And then I'm gonna boost the heck out of it. I haven't had one yet. Those big ones that come every once in a while where we are just crying, laughing the whole time. That's what I'm waiting for. I'm waiting for that to come. So I am going to do OJ today in 3 minutes. Actually, my dog wants me. So I have to let the dog out. And then I'll start OJ. So however long it takes my dog is how long it's going to take for me to start OJ. Hi, Anthony. I believe that. I think you told me that before. I don't care one way or another. TikTok goes, TikTok stays. I don't care. I really just don't. Um, I'd rather be safe in the United States. So maybe I'm leaning one way. I don't know. I don't care. I don't care. Whatever happens, happens. Oh, CJ! Oh my gosh, CJ, I almost forgot. Guys, it's time. It's time. Don't leave, don't leave, don't leave. Nobody leave. It's too late. Somebody left. Go get that person who left. Guys, you had a job last night. You had homework. And boy, did you do well. Now, I did ask for no inappropriate things on here, and sorry. Nobody listened. I didn't even listen. I put inappropriate things on here. Okay. Yesterday during the stream, hold on. Sorry. Yesterday during the stream, I gave you this list, this Amazon wish list. And I said, put on here Things that Fozzie should want. And you delivered. Here, you really delivered. We're going to look at this stuff. Okay. Inspired by my list. I don't even. Okay, let's. Yes. Yes, I think that he would love those. That was such a good idea. Oh, look. You can. You can get it with this too. I love it. All right. We got those little socks that hold hands when they get close. They just hold hands. Aww. Oh boy, I hope I didn't get in trouble for that music. I can't read that. Oh wait. That's something different. An airplane plush. That's so cool. That's perfect. That that was you. That's you, Fozzie. Oh, the beer. I was looking at this too. The only problem is I don't know how well bottles do. He would have to get cans. And I can't tell how comfortable the inside is. See that does not look comfortable, does it? No. The inside needs to be more comfortable. Is this one of those weights? Yeah, you get two of them. And you can do weights. You could do cans though. I mean, you could. Yes, I do work out. Lifting beer. All right. Oh man, I wish. If you have to ask if it's too early to have beer, you're an amateur and we can't be friends. That would go perfect in his room. Annoying you is one of my many talents, and it's Fozzie. Oh man, that's good. That's good. That's what Fozzie should want. The Australia Travel Guide. Does it show how big Australia is compared to Texas? I didn't see a bunch of these. These just popped up. I did not see a bunch of these. Is it Tui's? Is that how you pronounce it? I know it's something, but I don't know what Tui's is. I guess it's a Texas thing. Tui's? It's alright. You guys understand it. I don't have to understand all of them. Boy, I wonder who put this one on there. Texas White Trash Cookbook. I'm sorry, hold on. Okay, now that's just inappropriate, guys. I can't click that one. Oh, a beer. Tui's beer. There's a coffee cup. And there's an A over here. Ant. A coffee cup that says ant. Hold on. 2 minute timer. He doesn't need a 2 minute timer. He has that already. This is not it. I just need to find page 2. Wait. I put way more stuff on here. Where's everything on the list? There we go. Yes. Yes, those are awesome. Those are awesome. Look at those. Are they real Crocs? No. But that's fine. They're still awesome. I like those. Oh my gosh. Okay. I agree with that one. We just need $9,000. No, get. Oh, free shipping. Get. I can't do this right now. I'm going to need a picture. Get away. I'm going to need a picture to make sure I get the right size, Fozzie. Send me a picture. Send it to Donald. Lafayette, please go away. Don't knock the camera down again. Bud Light. Boobs and beer, that's why I'm here. they're, gonna, they're gonna need bigger cans, he said for the last one. A Fozzie Bear. A Fozzie Bear. You know what he needs? He needs like a 7-foot Fozzie Bear. Does it come in 7 foot high? Oh, wow. Oh, wow. Oh, wow, that's a good one. Yeah, that's $1,000 right there. Look at that. That is sweet right there, guys. That is really, really, really good. Only one left in stock. Well, yeah, that's really nice. Franco Harris. Oh, nice. I like this better. Ah, Lynn Swan. Bradshaw. Look at him. That's Fozzie. And a drone, obviously. Wait till you see the drone T-shirt that Lena's picked out. It's so good. It's so good. I think it's my favorite thing in this list. Oh, for her pleasure. For her pleasure. You got the ones for her pleasure. Guys, that's so awesome. I can't believe how thoughtful you are. And you know that he is also thoughtful. My other car is a private jet. Warning, I may spontaneously talk about airplanes. How planes fly. I can't read that. It's too tiny. My eyes. I can't read it. So, you guys just read that yourself. Oh, I think that says magic. I love that. I love that. Okay. Glow in the dark dinosaur fossil. Hey, he looks like you. I don't know what this is. I can't. Yes. Yes. Foxy Fly. Volume 2. Sorry. Okay. Okay. That's fine. Yes, I can see that one. Monopoly. What kind of Monopoly is this? Iron Maiden Monopoly. Nice. Nice. Seven son of the seven son. Oh. Are these real or is it something? Hold on. Oh, it's not real, but that's all right. A tiny cowboy boot with the state of Texas symbol. It would be. It would have been better. Oh, it's a fridge magnet. A real pair of boots like that would would have been way better. Oh, a head massager. There you go. I've never tried those. I just feel like they'll get stuck in my hair. Oh, I love that. I love that. A brush? Okay. I mean, I love those brushes. They're very good. Well, I wonder who put Tim Tams on your wish list. Tim Tams. CJ. Oh no, Vegemite. I'm not clicking that. I'm not clicking Vegemite. You guys know what Vegemite is. Alright. A mankini. Yep, yep, yep. Over the shoulder boulder holder. They picked black though. Okay. Red tinsel eyelashes. Yeah. Oh, I wish we could see them on him. And there, these go with it. Look at that red curly hair. Oh my gosh. Oh, we got books. Wow, someone really knows Fozzie. They got him books. Jury instructions. Jury instructions. CJ. The law dictionary. That's perfect. That's perfect. I don't think we can buy him medicine. Yes, we can. I'm wrong. we could we could get him 17 bottles of this. Yeah, absolutely. Oh, a prostate massager. Oh, and a book. It comes with an ebook. Oh, Fozzie the Bear slippers. Oh, yes. 2 minute miracle chow. I bet this is a 2 minute timer. Yes, it is. Yes, it is. Another book. 2 minutes. Book 6. I'm surprised at how many books are on your list. It's your ship. Management techniques from the best damn ship in the Navy. You could have written that. A Navy SEAL's bug guide. How to turn your house into the safest place on earth. Oh my gosh, that's perfect! Shake your booty. Isn't that perfect? Someone tell me who put this on his list, because that was a good find. Texas license plate. Yep. I think it was. I think it had to be CJ. No, he doesn't do cans though, guys. I identify as water. It has to, wait. There is a bot. Oh no, that's not a bottle koozie. You can't do that. No. No. A beer glass. What is this though? I guess you put the glass comes in a cute barrel. Old lives matter. That is kind of cool though. Sorry, no hablo. Nope, can't say that. I think I'm on this one. This guy is awesome. Yep. Whoever picked that one out, yep, knows Fozzie. I'm not trying to read that, but that's cool. Thor's hammer. What is it called? Oh my gosh, I can't believe I forgot the name. Meyer? Oh, what's Thor's hammer? It doesn't matter. It's a bottle opener. I guess you smashed the bottle. Just kidding, there's a thing right there. See? Are you worthy to pick up Thor's hammer, though? Yeah. Are you drunk? Old lives matter. Yeah. Need beer. Oh, yeah, loading. I like that one. Aw, it's a U. Like in the word color. It's a U. It's a U for Fozzie, so he has a great big U. Oh man, that would be so good if he went into work and carried that with him. Oh god, that's so tempting. That looks so cool for Fozzie to see. Aw. Which key does he put in there, though? The doghouse key. The doghouse key. Oh, Fozzie socks. Annoying is one of my many talents. That's the second time we saw that. Is someone telling us something? Lego, Fozzie. With a banana. No, boomerang. Is this a banana or a boomerang? Because if it's a boomerang, then it's Australian Fozzie. Sorry, can't. Rating by World of Warcraft. That was cool. I like that one a lot. That was a good one. World of Warcraft. It's a mouse pad that's LED and everything. Oh man. And then Waka Waka. World's okayest walking. World of Warcraft cookbook. I would not eat the crap in World of Warcraft. No, absolutely not. Oh, muscle massager. You got a muscle massager. I have no idea who put that one on there, CJ. Night vision goggles. And there's a bear for his drone so he can find his drone again. Happy Nuts comfort cream. That's not okay. I need to get rid of that. I can't have that here. The goat. A goat trophy. Greatest of all time trophy. Oh yeah, because you say it's cold in Texas. Someone put a hat on there. A heated. I was normal 3 drones ago. We're almost done. This is a belt buckle that holds your beer. And it... Nope, it doesn't show that it's... Oh, you can put it in the shower, too. This is not a belt buckle. It looked like a belt buckle. No, this is just a suction cup so you can take your beer wherever you go. This is the belt buckle. Hold on, I missed one. If you could read this, bring me some beer. This is a belt buckle that flips open to hold your beer. Oh no, it doesn't flip open to hold your beer, it opens your beer. It flips open to hold your beer. There. That's the belt buckle. And I think this is my favorite of everything. This is Lena's put this on. Drone pilot. If I duck, you should too. Scroll back up to the muscle massager for a second. Don't click on it. There. Are you pleased to see me? No, it's just my beer. Yes, this would go great with his hair. I can't read what that says. I don't know what that says. I can't read it. Type in all caps. Premature ejaculation club president. They didn't just put you in the club. They made you the president. That was rude. Oh wait, we saw these. Okay, we made it. We made it. We made it to the end of the list, guys. Okay. One of these things is being sent to Fozzie's house as we speak. If you were listening to me at all, you know which one. I can no longer read chat at all. My eyes are crying tears. Oh. Order one for Bill, too. Don't type Bob on that. Guys, you guys did great. That was really, really amazing. Thank you so much. That was so good. One of these things that you guys picked is being sent to Fozzie's house right now. Thanks to all the gifts that were sent to me today. So you guys just picked one of those gifts yourself and sending it to Fozzie's house, and he thanks you for it. Wait till he gets it. All right. Thank you so much for coming out today, guys. We really, really, really appreciate it. I shall see you all in a few minutes when we do OJ, or I'll see you all later. Bye, guys. Behave, okay? Bye.
Got this life that goes digital dreams through the screen, her blue eyes gleam. just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's life.